So as people are finishing their lunch and arriving here, I think we can get started so that we start to have the discussion on AI and data protection in the G20. Of course, we could not have all the G20 members here because it's kind of difficult to have them all in the same room and then to have a meaningful panel in 90 minutes with 20 plus representative. But we have decided to have some of the most relevant, if we may say so, voices in the G20. Coincidentally, some of them are members of the BRICS grouping, so it would be like a BRICS plus EU representing the G20, some of the G20 trends, right? Of course, if we have in the room other people that may be from other countries and they are or other organizations that have impact and connections with G20, so they are more than welcome to chip in. I've instructed our panelists to keep their presentations to, let's say, 6 or 7 minutes so that we have time for debate and also questions from the audience. So let's try to keep it as interactive as possible. I think that given that we are already 15 minutes late, we can avoid to have long introductions and get directly into the discussion. The idea is really to have an overview of what are the main trends at the national level in the countries that are represented, or in the case of EU, the bloc that is represented, and how these national trends can impact G20 discussions, and how G20 discussion could have an impact on the national or regional trends, right? So I think I could directly give the floor to Tainá for the starting the dance with our Brazilian overview. The floor is yours.
Thank you, Luca. So let's start with samba in this afternoon. Good afternoon, everyone. It's a pleasure to be here today. Thank you, Luca, for the invitation. So Luca told us to be provocative and critical and to emphasize two main issues. What have been the most recent development in AI and data protection regulation in our region countries, and what could or should be the impact of such developments in G20. All of these in 7 or 6 minutes, so I take some notes. Of course, the commercialization of foundational models has revigorated discussions about the global governance of AI and data protection, as these models use huge amount of data to be trained. And by global governance of artificial intelligence, we could understand as the process through which diverse interests that transcend borders are accommodated without a single sovereign authority, so that cooperative action may be taken in maximizing the benefits and mitigating the risk of artificial intelligence. That says Vice. So the United Nations Secretary Antonio Guterres, British Prime Minister Rishi Sunak, OpenAI CEO Sam Altman, our President Luiz Inácio Lula da Silva, and even the Pope have all argued for the creation of a new international AI body recently. Since 2016, the Organization for Economic Cooperation and Development, OECD, has been undertaking technocratic work through networks of experts to produce analysis and best practices for AI. In May 2019, OECD member countries adopted a set of AI principles designed to promote use of artificial intelligence that is innovative and trustworthy and respects human rights and democratic values. G20 leaders subsequently committed to a set of non-binding AI principles that were drawn from OECDs. In November 2021, 193 member states adopted a UNESCO recommendation on the ethics of artificial intelligence designed to guide signatories in developing appropriate legal frameworks. The UNESCO AI recommendations outlines principles substantively like OECD's, yet the OECD's principles were not mentioned in this document. Given that the OECD and G20 countries, which account for the vast majority of the world's AI development, already agreed to the OECD AI ethics principles, the failure to acknowledge existing work is unconstructive and a waste of resources. In 2023, the G7 jointly called for a Hiroshima AI process to enhance cooperation in AI governance, while the UK announced that it will host a global AI summit in late 2023, focused on AI safety. And Brazil. In Brazil, we are in the year of the G20 presidency. I am part of Task Force 5, which discusses inclusive digital transformation and the challenges, opportunities, and the governance of artificial intelligence. So, during 4 months, we had many sessions of discussions and have just released a statement with recommendations for the governance and responsible development of artificial intelligence, including the need for mechanisms that encourage the sustainability of this technology. Furthermore, we are discussing a strategic AI plan, redesigning the Brazilian AI strategy, and in the regulatory sphere, the regulation of artificial intelligence, which have the key aim to protect fundamental rights and to ensure the implementation of safe and trustworthy AI systems to benefit of human person of the democratic regime and scientific and technological development, besides also prevent and tackle discrimination bias. The text brings a risk-based approach and includes the National Data Protection Authority as the AI agency. In this regard, our Data Protection Authority recently published a decision determining the suspension of AI data training by Meta for violating fundamental data protection rights. There is still a long way to go, and it's important that Brazil, during the G20 presidency and in such a relevant year of discussion, manages to approve the regulatory framework as a legacy and presents ways to encourage responsible Brazilian technology. Thank you.
Thank you, Taina, for this introduction and this overview of Brazil. And actually, I also would like to apologize with the people in the room because I forgot to introduce all our speakers. So Taina Junquilha, she is professor at the University of Brasilia and works for the Brazilian Senate. Thomas Lerninger, he is director of Epicenter Work, an NGO, a European NGO, but based in Austria, in Vienna. Aifang Ma, she is professor at the University of Peking and also one of our CyberBRICS fellows. Then we have Daniel Kirimi, that is also one of our CyberBRICS fellows. And we have Zai Viva, also one of our CyberBRICS fellows. All right, so proceeding in BRICS order, now is time for Russia.
Well, thanks very much, Luca. Great pleasure to be here. Thank you very much for introducing. I will speak a little bit. You know, beauty of being an academic is really that you get to be critical and not being criticized for being critical. So I just wanted to go back to the fundamentals. Does anyone of you here in the room actually know how many countries are in G20? And then who else? So who does UN Secretary General represent when he goes to G20? 193? Who does EU represent when they go to G20? Who does African Union represent? Now another question, is the first G20 country, are they the largest economy in the world? They're not. The G20, the country that has the 20th largest GDP in the world is Switzerland. It's neither in the EU, no in G20. As a matter of fact, many people have called G20 the largest transgression on global governance since 1945. And yet, here we are, G20 setting the tone. But let's go back to the fundamentals. Why was G20 created? Was it to maintain peace and security after the World War II? No, continue. It was supposed to be to save our countries from economic crisis or help us coordinate with the crisis, mainly economic and financial, that were happening ever since. Well, today we are in a full-fledged or inflection point where our economies are about to be fully embraced by AI, or AI fully embraced by our economies. But I also feel, and again, being here critical, is that our politicians somewhat like this topic. They just jump on it because it's cool, it looks good, and then yeah, it's a little bit like hype. It's like VC. It's like a political VC hype. VCs put huge amount of money in the companies that may or may not justify that type of valuation, the same way our politicians put the same way of their political capital in AI with no idea whether actually it will pay back. Now, today, and I mean today, like the 17th of July, 2024, it's actually the most exciting time to have this panel. And let me tell you why. Today, the King's speech in London marked a really turning point for a position of the UK government in terms of AI regulations that have been quote unquote leading or driving, well, actually not quote unquote, they were being quite really adamant in trying to position themselves as a leader in terms of global AI governance debate. So we went from hands-off approach that was called AI safety to hands-on approach, who is yet to be known what it will be called. And this is also another thing that always baffles me. In the classical political terms, when we don't want to deal with a problem, we put it in the title. Like, Inflation Reduction Act led to the largest inflation in spending in the US history. AI safety processes were all about, we don't want to regulate, do whatever you guys want. So there are all these misnomers that I think now even the politicians are starting to recognize and starting to say, okay, we've been jumping on this bandwagon, but now we're actually reaching the stage where we need to see whether our political capital needs to be returned. And again, mentioning the King's speech, the turning point between hands-off approach to actually, let's see what we can do. Quite a few other G20 countries are going exactly through the same process today. So Korea, which was a partner of the UK in the AI safety process, said, well, they didn't say it, but because of the change of the leadership in the parliament, now from hands-off to more regulatory stance. Who knows which way US will turn based on November, but there are quite a few changes in the standing. Also yesterday, I said today is the most interesting time to have our panelists because yesterday, for those of you that didn't know, until 3 p.m. local Eastern time in New York, there was a deadline for silent procedure for states to agree, 193 member states of the United Nations to agree on new digital compact of the United Nations that will be adopted in September in New York. And there is a silent procedure is there for a reason. But those of you who are, and legal nerds like myself, it basically means if you didn't say anything, you agree. Well, let me tell you, when you reach that stage, normally nobody raises your voice, very seldom. And believe me, a digital compact, quite a few countries raised their voices. Now the co-coordinators are Sweden and Rwanda, so they have to come up with some sort of compromise and have to do it quickly during the time when nobody is in the office because it's vacations. But in September, all our member states will be voting on this digital compact on which the Secretary General put his legacy on the line, basically. And we don't know what will come out of it. The advisory body that has been created in the UN, again, has been hit and miss. Quite a few people on the body themselves are going through questioning of their legitimacy in terms of how they approach AI. But the point is we need to really dial down the hype around it, whether it's VC hype or PC hype, and really get to work. Now, I will speak about perhaps Russia, since Luca so pointed out. The situation in Russian Federation is on AI and data protection is the following. Some of the legislation on data protection is about 20 to 30 years old. It has been updated and re-updated. Protection legislation, I believe it's a federal legislation 152. The latest amendment came in June 2023. There were quite a number of other amendments, legislations, and federal projects in terms of AI sponsorship, investment in education, and so on. But really, what's happening there is that everybody agrees it's a mess. And everybody agrees that it's time to update, unify, and review. So in 2025, just like there's a global digital compact, the Russian Federation will be going through the digital compact process. There are early drafts where the idea is to really bring all these different strains of the legislation together and give people a kind of unified view of what is to expect. I will stop here, perhaps, but again, perhaps before I stop, I didn't want to leave you with an impression that I'm only hypercritical of G20 or the United Nations. As a matter of fact, the G20 did manage in the past to save our economies, to coordinate a global action. It needs to continue doing that in the digital space. The United Nations is the only universal organization that has 193 countries as member states. And therefore, that would be probably the right venue to take the thinking from G20 and many other places and make sure that everybody's part of that process. Thank you.
Thank you very much, Daniel. Also, to highlight the kind of complexity we face, on the one hand, the need to do something as quickly as possible, but on the other hand, the understanding that it's very difficult to do things quickly. And especially when people disagree on so many things, and there is so much hype around things. So it is already very difficult to do things quickly when people have the same kind of understanding and you base your conversation on evidence. It's much harder when people have completely different understanding or no understanding at all, and the little understanding they have is based on a very inflated statement on marketing statement, basically, on AI. All right, on this note of optimism, let's move to India to understand what is happening there and how this has impacted the G20 or could impact the G20.
Thank you, Luca. Thank you, Daniel, for that reality check, which is much needed, I think, and I agree with the problems with the G20 and also the co-optation of UN processes in AI regulation. Having said that, we all know G20 happened in India last year, Brazil this year, South Africa next year. And so this is, given all these realities, still perhaps a good opportunity for a non-Silicon Valley influenced idea of AI regulation to come up through the G20, perhaps more of a global South focused approach to AI regulation to come up. And it's funny which forums turn up these approaches sometimes. So I will talk a little bit more about India. As you know, India pushed the concept of digital public infrastructure last time when it was hosting G20. But I want to talk about data protection today, since that's the panel, and a little bit about the lead up to the data protection law that India has. Discussions about it began after there was a judgment from the court that said privacy was a fundamental right in India. There was a report called the Justice Sri Krishna report that made what I think is a philosophical advance in this field, where it held the relationship between the collector of the data and the person from whom the data is collected as a fiduciary relationship. And you know that when there is a fiduciary relationship, that means there's a duty of care. And so the person who, or the entity who collects your data has to act in your best interest. So the person about whom the data is called the data principal. He's not a data subject or a data owner, but rather a data principal. And so the use of personal data is framed as a principal agent problem, like we call this in economics and I think in law as well. So I think that using this sort of understanding of the data relationship, we can think of a way to frame the deployment of artificial intelligence also as a principal agent problem. You can imagine thinking of the collection of data to replace you in your job and create unemployment in the economy in general as a principal agent problem. This is not why you agreed to give up your data for an AI model, or even the degradation of services where you know, a model that is inaccurate is deployed in certain contexts where accuracy is really important, but it's cheaper to deploy the model than to hire people who will check for accuracy. And this affects your life in a way that you did not imagine when you gave up your data for this purpose. Or markets end up being consolidated, or if you're in the financial sector, there's predatory lending that happens using your own data with the use of AI models that use your own data. And so this idea of a principal agent problem can be useful for jurisprudence in AI regulation. I do, however, worry about, you know, it may not always be a good idea to bring all these determinations of political economy issues under the judiciary and under the interpretation of a law, but you know, and also under the topic of personal data, because a lot of these political economy problems are not necessarily about personal data. They're just about how products are deployed and who gets a say in how products are deployed. So it doesn't always have to be the person whose data is used. It can just be the person on whom the product is deployed. But I think that even so, understanding this as a fiduciary relationship brings a sort of stopgap. It's a good stopgap arrangement in law, and it stops the kind of free-for-all that is occurring today with the development of AI models, because even basic data protection, even data protection that uses different concepts of the relationship of data, I think is today being underutilized in the regulation of AI. And if data protection as it exists today was utilized to its full extent, you would probably not see the kind of AI development that you see today. That's one thing. One part is personal data, but India has also had innovations in thinking about non-personal data. So even the framing of the concept of non-personal data, the regulation of e-commerce platforms in terms of thinking of non-personal data, the concept of digital public infrastructure itself, which relies on the existence of some kind of non-personal data in certain cases, have all been innovations from India. One thing is that these innovations have arisen in a context where the Indian government has been trying to keep the influence of foreign capital at bay in a certain way. So large foreign capital, large monopolists like Amazon or Google. But it is also the case that this response has been motivated by very limited and almost oligarchic concerns in terms of trying to protect large capital or some elements of large capital within India. So it's a fight between large domestic capital and large international capital. But what G20 can do, or you know, like-minded countries at G20 can do, is take this concept of using public protocols on top of which the private sector can build products as an anti-monopolistic concept that can be deployed in various countries using different sorts of coalitions of people who are interested in anti-monopoly or in antitrust. So I think that the idea, the framing of non-personal data as something that the state can govern and can make rules around is an important framing because it shows you that this is an area where also rights are implicated. It may not always be the right to individual privacy, but there are rights that are implicated within the creation of non-personal data as well. So for instance, there's a right to group privacy, and there's economic rights that are implicated. And with the creation of large AI models, I think these rights become even more important. Am I running out of time? 1 minute. Okay, so I just want to highlight there is a response from farmers organizations in India to the creation of AgriStack, which is supposed to be a digital public infrastructure for agriculture, where they talk about the protection of their own economic interests that they are scared for with the creation of this infrastructure and the use of their own data, both personal and non-personal. So I think the intersection between economic rights and data rights is the big innovation that India can bring to this conversation, and that the G20 ought to take seriously, because all kinds of new technologies that enter our lexicon or our environment should be open to negotiation in the way that they develop. Yeah, thank you.
All right, before we pass the floor to China, let's try to start to highlight some macro trends, because I think that is also the purpose of the workshop. So we have seen that there is willingness in all countries, in all examples we have analyzed, to regulate somehow. Something already exists in all the 3 countries. We have seen that there is already data protection regulation, and to some extent applies to AI. Of course, most of AI most of the resource used by AI is personal data, although you can have also non-personal data. We have attempts to regulate AI, but we still don't know how in Brazil. And again, most of it may be driven by political willingness to show off that you are doing something, but not necessarily doing something. We have an interesting trend in Russia to take advantage of the confusion that is that exists in normative terms to try to centralize it. It may be a choice to streamline things. It may be a choice to control things. We will see. Interesting the Indian example of because many people out of India think about India as the leader in digital public infrastructure, but then when we scratch the surface, we also need that at the end of the day to do things. Although there is a lot of digital public infrastructure going on, it boils down to a choice between foreign versus venture capital versus domestic venture capital. So it's, again, it may be highly concentrated, nothing against venture capital per se, but they may be very, very concentrated, and the choice that are proposed, the solution that are proposed may not be necessarily solutions, right? So let's see how China is dealing with this with Aifang Ma. Please, Aifang, the floor is yours.
Thank you so much, Luca, for this opportunity. And thanks for coming today. Well, what I wanted to see is kind of, well, generally speaking, the Chinese government is pursuing a developmental agenda with the data protection. So actually, the Chinese government is kind of under a draw pressure. Well, I tend to use 2019 as the division line in my publications. Well, actually, before 2019, China actually does as the United States, in the sense that the government use a property-based approach to regulating the data. So the personal data and the non-personal data are actually mainly controlled and regulated by the firms actually. And then so from 2015 onwards, the Chinese government has progressively built a relatively mature data strategy. In 2015, there is already the national big data strategy. And then at that moment, the priority is really to unleash the economic potential of the data for boosting the economic upscaling. And then there is the very famous Made in China 2025 strategy. So actually, this is also a very ambitious strategy trying to change China into a global manufacturing power by 2025. And this is a politically very sensitive strategy to such a point that today Chinese academia and the industry alike are kind of not allowed to publicly talk about this strategy because it's a bit sensitive. And then the most recent data regulation rule is released this year in March. It's kind of about the data circulation and the trade places in China. So actually the regulation is, the data governance is, it depends on whether it is the personal data or non-personal data. So actually if it is the personal data, so the production and the processing of all the personal data should be stored within the physical infrastructure inside the country. And then if the personal data of Chinese people is processed outside China, then this company should have representation on the Chinese territory. And then on the non-personal data, there are two types of non-personal data. So depending on whether the Chinese Cyberspace Administration of China defines it as important or non-important, then they will go through the security assessment. I know that it's a bit complicated. Non-important data can circulate outside China freely, but if it is important data, it must go through the security assessment before being exported outside the country. So this is the latest regulatory changes. So what I wanted to share, what I wanted to say today is actually the big power competition. So the big power game between China, the EU, and the USA. Actually, the way in which, so the data governance approaches of China is profoundly influenced by the EU and the USA. So the way they are going to deal with the data. So for instance, there is the federal data strategy of the USA in 2019, which actually kind of changes the American data governance approach to more centralization. And also the EU 2020 data strategy, maybe Thomas can tell more. So this is also kind of a strategy towards more centralization. So the Chinese data regulation systems actually goes in parallel with the data governance system in EU and in China. So what I want to say is that the Chinese government is trying to produce what we call the Beijing effect. So in parallel to the Brussels effect. And the evidence on the ground has shown that actually in a similar way as the EU, so the China is also kind of trying to become a kind of a regulatory power for the data governance. Today there is kind of an increasing number of jurisdictions who are imitating the way in which the China is doing the data governance. So, for the future, I think that so the China is known for championing, for upholding the cyber sovereignty doctrine. Well, in the digital area, there is also maybe the data sovereignty, the AI sovereignty, things like that. So for the EU and the USA is the same thing. I think that the emphasis on the sovereignty thing is a driver for fracturing the global, the transnational data governance framework. And also in particular for the inclusion of the territorial effects in the data governance rules, these kind of very easily to produce the conflicts between different jurisdictions. So what I hope for the Brazilian presidency for the G20 to do maybe is to try to kind of to initiate a soft law approach for the transnational data governance, and then to reduce the risks of the fragmentation for the transnational data governance. That's all. Thank you very much.
Thank you very much. I found to bring into the debate also this developmental approach that China has, and that indeed actually when we look at how many governments are positioning themselves in terms of data policy is contaminating a lot of thinking outside China. And I think that, again, I think that is a very interesting movement. We are studying this. The Beijing effect you were describing is not as well sponsored, and there is not such a good PR as the Brussels effect, but it is indeed taking place either because of other countries are copying it or taking inspiration, or because also part of the Beijing effect is also being driven by investments like through the digital Silk Road, or this kind of more assertive, again, economic developmental policy of China. Before we get into the EU, let me give the floor to our friend Sizwe Snail Kamtuze that I forgot to present. Sorry, Sizwe, I hope you will apologize if I forgot to introduce you before. So Sizwe Snail, he's not only a very good friend, he's not only a very good partner of our CyberBRICS project. He is professor at Nelson Mandela University, and he was the former one of the former directors of the information regulators of South Africa. So Sizwe, thank you very much for being with us again today, and please, the floor is yours.
Thank you, Prof. Bailey. Thank you to everyone listening in Rio. I was hoping to be there this year, but unfortunately this year it didn't work out. Hopefully next year again. I wanted to do a slightly longish presentation, and then I got the email from Luca saying, please, please, please focus on updates, strictly updates. So I'm going to touch on the updates that have happened in South Africa. So first of all, I want to make the point that South Africa does not necessarily have AI legislation in place, and that we are still in a process of formulating AI legislation. To that extent, the common law as it applies has been used to basically deal with various aspects of AI, be it aspects of data protection, copyright, or other aspects relating to AI pertaining to data protection. We've had recently a spate of cases. Last year, when I was there in Rio, only the Parker decision and the Aliyu decision had been decided, where both an attorney relied on AI as well as a presiding officer relied on AI, and they got into hot water. We do, however, now have the new decision of Makunda versus Indigo trading as Spur. And in this particular case, a self-representing litigant, in other words, this was a gentleman who did not have a lawyer, he drafted heads of arguments and successfully defended himself using and relying on the assistance of Google as well as other AI-based technologies. And the court said, look, he has not done anything wrong as long as the sources are correct. And the court also said that, you know, maybe we as lawyers and judicial officers, we must watch out for AI, as one day it may replace our employment. Now, earlier on in this year, 5 of April 2024, our Department of Communications and Digital Technologies in South Africa developed what they call the Artificial Intelligence Planning Discussion Document. You will see I've said the good, the bad, and the ugly. So this is a document that has had a lot of criticism from a lot of stakeholders as well as legal experts. Let's start with the good. The good that is that finally there is some form of document or national policy or strategy towards developing a white paper on AI. It also proposes the creation of a specific AI expert group that will also advise government, in particular the Department of Communications and Digital Technologies, on aspects of AI. They have also given themselves a target to develop and implement regulatory approaches to AI from 2025 to 2017. You will see later on in my critique, I will be saying, but this is too short to be developing any legal framework. Then obviously as well, there is going to be legal certainty regarding AI in terms of this plan, and also talks about government pumping in the necessary resources in developing AI as well as e-government services. Furthermore, on the good, it seems to be making reference to data sovereignty. In other words, the concept of data sovereignty in the context of AI has also been placed there as an important factor. And I think what is also very, very important is the ethical considerations regarding the use of robotic and autonomous devices, social risks, as well as the the consequences of using AI models and them being used for criminality and military purposes. So that is the good. Let's talk about the bad and the ugly, and I'm going to try and keep this short. The bad and the ugly is that this discussion document is 53 pages. It was published as a draft, but it was published in its form. And a lot of our commentators here in South Africa, like peers, say, look, this document shouldn't have been published in this form. More attention should have been made in terms of the deliverables in this document, who will be responsible for what. A lot of heavy jargon is used. In other words, the plain legal language principle has also been completely ignored. And it also seems as if bits and pieces of AI strategies from all countries around the world have just been mosaicked together. Furthermore, what we call the AI Intelligence Institute that was set up as early as 2022, it really hasn't done much. And if one looks at this policy document, it really focuses around the Artificial Intelligence Institute to assist with drafting policy, as well as assisting in creating a regulatory framework. As I said earlier on, I doubt one can draft an AI legislation in 12 months. It's taken the EU years, it's taking America years, it's taking Brazil years as well. So I don't think that it is a realistic objective to say that this piece of legislation will be done within 12 months. Briefly, on the African continent, as we are talking G20 being South Africa as well as the AU, I'm adding on the previous comments as to who or what is the G20. The AU has also come up with a digital strategy for Africa with regards to AI governance. That is something that we should have a look at, that is developing very quickly in South Africa and in Africa as a whole, as well as the work that has been done by AUDA, NEPAD, together with the AU to, like I said, develop an African strategy. Now, last but not least, data protection. I'm not going to talk about data protection. We do have a data protection law in South Africa, the POPIA, so I'm not going to talk about that again. But there has been a very, very big contentious point in South Africa in the last couple of months about telemarketing and whether telemarketing falls under the ambit of Section 69, which basically regulates direct electronic marketing. There's been a big debate about that. Another thing that's been happening in South Africa from a compliance perspective is that the regulator has really been going in and using its powers to do assessments. Most of the national banks and renowned banks have been subjected to data protection assessments, as well as the political parties during our elections. You may know that we just had elections not too long ago. So in terms of compliance, the regulator really using its powers to do assessments. Last but not least, so that I don't exceed the time given to myself, there are some interesting milestones in terms of the enforcement that we've had in the last, should I say, 24 months, right? We've had the creation of certain guidelines. There's a guideline on security breaches. There's a guideline now that's being drafted on direct marketing that the regulator has been talking about. There's a guideline on political parties, as well as direct marketing there as well. So there are various guidelines that have been issued by the regulator. And very most importantly, as of last year, the regulator has started giving fines. I'm not going to go through all of these decisions. I will share the slides with Prof. Bailey. You can share them with everyone. But what's important is the latest decision of FT-RAMS. Now, in this decision of FT-RAMS, an enforcement notice was issued. And it seems as if, in terms of telemarketing, like I said, it is the regulator's view that telemarketing does fall within the ambit of unsolicited electronic communications. However, the critique around that is that, you know, the definition of electronic communication or of electronic form most probably does not include a telephone call. And for that, one would have to go to the definition, section 1 of the POPIA, and it specifically talks about any text, voice, sound, or image sent over an electronic communications network. And that's the first part. The second part, which is stored in a network, and then the last part, or in the recipient's terminal equipment. So the critique against the regulator is to say, but when you're doing cold calling and telemarketing, you are not necessarily sending a data message. It is not being stored. It is a telephone call, and therefore there's a big contention as to whether direct marketing and telemarketers, electronic telemarketers, fall within that ambit. I would have loved to have said more, but that is the update coming from me. Thank you, Prof. Bailey, and thank you for everyone for listening.
Thank you very much, Silvia, for the update from South Africa. And then now, last but of course not least, our European friend, Thomas. Everyone has been hearing a lot about the AI Act, and arguably the EU is the region with the most refined regulation. But so I've asked Thomas to tell us to what extent there are things, elements from which other countries, not necessarily only G20 countries, all countries can learn from Europe, both in terms of successes and also miserable failures that I'm sure may abound as in any country. So please, Thomas, the floor is yours.
Thank you, Luca. Thank you for the kind invitation. I'm very happy to be here. As Lucas mentioned, I'm coming from Vienna, Austria, so you could say we started with samba and now we end up with waltz. And yeah, so what has Europe gotten right or wrong with the AI Act? I think there are certainly things that are very interesting and that show a good way of getting biases out of training data, having a product safety and risk-based approach towards AI. I think that is a very helpful approach to enter into this field. One thing that I would caution everybody in every piece of European legislation is everything winning or failing is decided by enforcement. Particularly about such novel technologies, even more complicated questions come into play, like the technical skill of regulators, the ability to actually comprehend things that are happening right now, their impacts on vulnerable parts of society, on certain industries. There is so much at stake here. And we can see in the DSA now, the Digital Services Act, that in order to get it right, you really need an open and communicative and transparent regulator that is willing to cooperate and go across borders, which is sometimes a novel concept if you come from data protection world, where data protection authorities are often perceiving themselves as silos, we know best, and not really talkative. I think an AI regulator needs to be talkative. But there are also very obvious things that I wished would have been in the AI Act. The biggest of all, of course, is the question of state surveillance. We have nothing in there that could actually limit the dangers of facial recognition, biometric recognition, and many other forms of automated decision-making that make law enforcement activities particularly dangerous. And it's not just going to predictive policing. The old-style facial recognition danger is not addressed accordingly in this law. The second big omission is copyright. Right now, we see all around the world that these hot questions are tossed to the courts, and I think that's wrong. Of course, it's brilliant of the New York Times to sue OpenAI, and we have now also the record industry doing that. But I would like to live in a world where it's not just very powerful actors with deep pockets that can afford to get their right or being paid off, like the Atlantic. Like, if you can either make a deal and get paid or you sue, there are many people that will be left outside of either option. And I don't think that this is fair. And this is not really asking the real questions. Like, if we follow the trajectory of copyright law, it is very obvious who will win. It will be the labels, it will be Spotify, it will be Hollywood. Remember the actors' strike? Those that already have the usage rights of certain data and that can make a case about this falling under copyright exceptions, under fair use exceptions, then suddenly having a whole separate catalog that they have created via AI and can claim that this is their right to license and use. That would certainly be a world in which the current trajectory of copyright is extended, with the artists, the creators being disenfranchised, but the aggregators, the gatekeepers being further empowered and entrenched in. That is something where the legislators need to act, and I think that is a global problem. And lastly, the whole question of like, which business models maybe we should really outlaw and ban? Thinking about non-consensual nudity, thinking about the use of AI agents in particular, for crime, for ransomware, for spyware, for many things where we could, I think, as a world agree that we really don't want to have it. And something like that, maybe there's now still a time to do it. And I feel like this window is closing. Stepping a little bit back, also reflecting on the fact that we are quite an international audience here, I feel that it's time for old jokes. In my community, there's this joke that we told ourselves over a decade ago. Our job is to explain the internet to politicians because they don't understand. That was the subtext. I think the joke is no longer fun and it's no longer true. Now everybody has an understanding of the internet. We have quite competing visions, actually, that on an international stage we have to fight about. Luca and me know each other from the fight for net neutrality. There are now vastly different concepts out there. If you look for China and new IP, and these are concrete proposals that are put to the table, they merit a discussion. I find myself caught up in the digital public infrastructure debate around digital identity systems and Atar in India and gov.br here in Brazil. And I also have the privilege of being in the DPI Safeguards project of the United Nations, heading the governance working group. Our job there is to create universal safeguards for digital public infrastructure. It's a horribly difficult task. And it turns out that suddenly having millions and billions of people into a digital system without any redress, any privacy safeguards, or any real thought about what this would do to the people that already live in a country that might not have access, might not have digital or legal literacy to even use these systems safely. These are secondary concerns, and they will fall on our head. And we are not even talking about making these systems interoperable. These are the operating systems of our modern societies. We have the technology first, and the legal framework, the human rights assessment indicators, the competency to actually roll these out safely, those are afterthoughts. That's the wrong way around. So right now, the trajectory of digital public infrastructure is this becoming a tool of oppression, and that is a very dangerous trajectory to find ourselves in. And I was intrigued when hearing that the Chinese approach to personal data is that this is dual use, and you have to distinguish between the important and the non-important. This reminds me of the old joke, personal data or data in general is the new oil. It is not. It is the new CO2. If you have too much of it about a certain population, you have very dangerous macroscopic trends that suddenly materialize. And the one solution is an old one, data minimization, privacy by design and by default. We know these things, like climate mitigation and how to save the planet. We would have the technology. We would just need the political decision to act on it. And the benefit of building these systems safe, meaning privacy respecting, is similar to the building we are in right now. Fire codes are costly. They increase the time to build a house. But it makes the whole thing much more livable, safe for people. And if you have to do it afterwards, it is even more expensive. So it's a design phase consideration. And maybe to close, recent memory gives us a great lens through which we could look at current challenges. We just had a pandemic. And this pandemic, I remember telling my team in March 2020, lean back, digital issues will be no longer important. Other things are primary now. We can work on our backlog. The opposite was true, of course. We never had such a hard time as digital rights activists working on things because suddenly everything was digital. And if we look around the world, we see so vastly different approaches to the same problem. We have, in some areas and regions of the world, simply the repurposing of existing anti-terrorism legislations, agencies, and technologies to fight the spread of the virus. Metadata, facial recognition, CCTV, any type of tracking people became a way to track the virus spread. That, of course, has a huge privacy cost to it. And in other areas, we have brilliant privacy-preserving technologies were created, like DP3P. And these are means by which we can actually achieve the same thing without the negative privacy cost. So these things are possible. The QR codes that we all use to prove that we are vaccinated or recovered or have been tested recently, those were also made based on a privacy-friendly standard and then could become a UN standard. So these things are possible. And it's certainly worth spending that extra brain power in order to create systems that, given where we are right now, globally speaking, are bad weather systems that can even protect us if elections or regimes go the other way. Thank you.
Thank you very much, Tom, for bringing all these very interesting elements into the discussion. I think that a couple of things that I really want to stress before we open for questions. First, the fact that so we focus a lot of efforts into crafting the legislation or the regulation, but then we forget that the most important part is implementation. So we might have wonderful debates that take years here in Brazil or somewhere else, and take a lot of inspiration from product safety and risk mitigation and risk management in the UI Act. But then if you don't implement it, you can check the box on the surface. There is a facade where you look like the EU, but then in practice it's very different. And secondly, and something that we are, again, working a lot in our CyberBRICS project in the different ways of regulating, considering not China with through investment, and also, I mean, DPIs themselves are a tool of regulation. So it's really what Lessig was writing 20 years ago about code is law. It's really, you have really a practical implementation of how you regulate an entire society, an entire country through technology, what they could do, the behaviors they can engage on, how they can transact amongst each other through code, through software. So that is also something that one has to think about. And what you were mentioning, that cannot be an afterthought, the kind of values that are baked into it, because it is not neutral. There will be some values baked into it. And if you don't think about it before, you then have to try to solve the problem that you have created, right? So there is a lot of very interesting thoughts for the discussion here. I am pretty sure there will be questions. I already see a hand. So,
I have a question also.
Okay, so we have two questions, one from the panel. And so let's do this. Let's start with a question from the audience and then your question. And then if anyone else has other questions, you can raise your hand. We can take 2 or 3 and then have another round of questions in the next 20, 25 minutes.
Look, I had actually something to add to what Jai had said. I think one of the things that we should remember is that the Indian data protection regulation was born out of a conflict where the Indian government didn't want the fundamental right to privacy. And in the report that followed, which he also referenced, the Sri Krishna report, there was an attempt to strike a balance between economic growth and therefore the growth of the digital economy and privacy and data protection, right? And the non-personal data framework that we're talking about, I'm glad that you mentioned group privacy, because that didn't come up in the conversations around that time. There was no concept of privacy in the non-personal data conversation. At this point in time in India, at least over the last 6 months to 8 months, there have only been conversations around liability with respect to AI. There have been no conversations around personal data protection and AI. And I think it's important to remember in this context that the data protection law, which passed last year in India, actually excludes publicly available personal data from the ambit of data protection. And therefore, we treat the data protection law as not a data protection law. It means that Clearview AI, which has lost the case in the US around scraping data of Facebook and social networks to train AI, will have a free run in India. So it's almost as if, and when we've talked about the non-personal data aspect, the focus on data trusts in that context in India was about how do we make more data available? And this bleeds into the discussion that we're having about digital public infrastructure, because the primary approach to digital public infrastructure has been to make consent so easy and so seamless that people don't even realize they've given consent. And there are account aggregators that are set as another form of digital public infrastructure, which can take data from multiple accounts that we have, and they can aggregate them, and there is no regulation preventing the misuse of that data or even the sale of that data to third parties. So the entire focus in India is not around data protection, but enabling access to personal data, whether it is in the public domain through no restrictions in the data protection law, or through in the private process through consent managers, which allow the extraction of data at scale. And all of this is rooted in enabling the training of AI. So philosophically, there is no scope, there is no focus on enabling data protection in AI in India.
So thank you very much. As this was more a comment than a question, I will comment on it because there are actually really 2 points that are very interesting. Well, one, probably because the Digital Personal Data Protection Act of India is one of the most recent data protection laws. It is interesting to see that actually the choice that maybe not many people notice around the world was precisely to include as a legal ground for processing the fact that personal data are published online, which basically is green light for scraping and training models. So a very successful lobbying from tech enterprises in India. A good friend of us that now is a very prominent lobbyist in an Indian, in an American tech company in India was telling us it was an excellent law. And I was telling him, yes, of course, because you can do whatever you want with the data, but it's not necessarily excellent for the data subject. And then another very important point that actually the right to privacy in India was created precisely because of a failure of a digital public infrastructure, Aadhaar, which was questioned by Justice Puttaswamy that won the case and created the right to privacy in 2017, precisely because of the misuse of the DPI. So I think that when we speak about DPI, they are a very interesting tool, but we always have to take this with a grain of salt because it's not always a rosy picture. We need to be a little bit more critical. Your question.
Thank you, Luca. So internationally speaking, there is already a consensus, in my view, on ethical principles and in AI data protection. And in this sense, I love the expression of the non-Silicon Valley that G20 presidencies in recent years can leave as a legacy. Because I believe that now what we need is to understand how to apply the principles in national context and how to balance innovation and stimulation, local innovation, create infrastructure. Do you guys agree that now it's time to understand how to put in practice all those principles? And a little second question. In Brazil, after years of discussion, like 4 years, there is a certain consensus in all sectors that we need to regulate AI. They accepted the regulation. But my impression is that, especially in countries in the global south, the big tech market is against and any kind of regulation. Everyone else accepted to be regulation, which increased the challenge because they confuse this discussion of regulating AI with freedom of expression, etc. So my second question is how to decolonize, or how you guys are facing, and if you are facing this same problem with big techs.
Fantastic question. Do we have any other questions from the audience? Otherwise, we can, yes, 2 questions. Let's take these 2 questions, and then we can have a quick round of answers.
Yeah, I just have a quick and simple question from China. I was in China last week or the week before in Shanghai, and I visited there's a special free trade zone, Lingang. That's a city that is being built, or that is built next to Shanghai. There was a data port that was built there, and we had a discussion about the liberalizing some of the Chinese data governance rules or the privacy rules that are in place. So I just want to understand a bit more about how those free trade zones, and I was told that there are a few around China, how they are structured and how is the data regulation applied differently to those zones than to mainland China. Thank you.
All right, let's take also the last question, and then we can have quick, can I just ask you? Yeah, but we need to have it for the video recording and for our online participant.
Hi, everyone. Thank you so much for these relevant perspectives from our BRICS representatives. And I'd like to take all of this into consideration and dive deeper into our discussions in the G20. As I understand, the G20, they function differently from other forums, right? They have like these 2 tracks. There's the Sherpas track and the finance track. And within each, they have all these working groups. And I'd like to know if you can expand a bit more on how these topics of data and AI are being discussed within these 2 tracks. Thank you.
All right, we have several interesting questions. Who wants to go first?
Thank you so much. I will try to answer your question. Yeah, I hope that you like Shanghai after your travel there. Yeah, well, I think that it's indeed a very crucial observation you made here about the differentiated implementation thing for the data governance in China. Actually, so in the regulation studies, actually, so the China, Japan, so the Asian countries belong to a group of countries which implement what we call a static regulation. So the static regulation means that within the state, the regulated firms are not treated in the same way. So the priority is not to kind of to promote the free competition, but the competition is orchestrated, so organized competition, meaning that the state picks up the priority firms, the priority sectors to support. So in the data protection, it's the same thing actually. So which you have very pertinently observed there. So meaning that in the case for Shanghai, for Shenzhen, for Beijing, actually, so these areas belong to kind of the free economic zones, meaning that the level of liberalization is higher than, for instance, than the inland China. So therefore, they have a kind of so the local governments are allowed to kind of to make more liberal policy, so to attract more investments. So this is a kind of the kind of the differentiation in the implementation for the data governance. Yeah, thank you.
Sadly, I cannot answer this specific about the G20 process, but I'm curious to hear the answer. Maybe someone else can take that one. I would like to come back to your question on the values in general, and I feel that we have, with the aforementioned Global Digital Compact, a great example of almost like a Rorschach text. Everybody can read everything into that, but it doesn't give you real guidance. It doesn't give you real answers. And I would say that this is by design, because these are hard questions. There will be winners and losers. And we're talking a lot of money here. And decisions that decide about the characteristic, the freedom of the societies we will live in. Ultimately, it's Luca mentioned code is law, yeah, in a way. This is on steroids, because the way in which not just your security system, your police will work, but also your education, your welfare system, your elections if you're having, certainly your media distribution, the information diet that people have, all of that. And I would say that we need to be much more inspirational and concrete. And we also need to be mindful about the opportunities and risks. And those are very obvious at this point. This is not a theoretical debate anymore. We have flesh to the stack. There are real victims and there are real perpetrators. And I would say that forward-looking regulation needs to address both. It needs to hold people into account for their business model, and it also needs to provide protections for vulnerable people. I mean, just to end with a water cooler story, it's like, Luca and me, we go so long back that we have friends who switched sides and are now working for big companies. And one of my former friends now is in the policy department of Meta. And their water cooler talk is, the policy team of Meta, the water cooler talk really is like, let's not have another Myanmar. Like, that's the bar in an office chit chat. If we can avoid it, let's not have another genocide.
I consider them still my friends. They are not former friends. They just have a different employee. With regard to the G20 question, that is a really very administrative question about G20. So I'm not sure that anyone here is very much. If you want to, yeah.
What I can say about Isadora's question is the experience of participating in the Task Force 5. Task Force 5 focuses in its efforts on developing recommendations to leverage digital innovation to advance the Sustainable Development Goals of the 2030 Agenda while ensuring inclusivity and ethical considerations. So after 4 months, we had lots of discussions, and we received also contributions of many think tanks all over the world that discussed about digital inclusive and ethical challenges of technology. And we published last week the statement with the conclusions of these contributions that we received.
Just also to make sure that we all have the same kind of expectations. One also have to remind that G20 is a club governance system where no binding regulation is elaborated. It's more about understanding which are the priority, aligning them, and trying to share good practices. So it's a little bit like the BRICS, if you want. Actually, the BRICS has been molded on the G7 or G8 at the time, and then the G20 has been built to include also the BRICS in the G7 and G8. So in G8, so it's very much about club governance. A group of friends that meet once per year and discuss things and makes declarations. So to be very frank, that is not something that changes the world, and no single issue has been changed over the past 20 years radically because of a G20 declaration, but is a very interesting forum to discuss things. So to try to advance mutual understanding and share ideas. I see that there is another question or comment here.
Yes, and just to echo you, Luca, and I'll follow with a question. The G20, it's not a forum to actually improve in terms of like concrete solutions. It's much more a forum to shaping ideas and to shaping an agenda that, let's face it, it's very polarized right now around the world. So having more spaces where we bring different stakeholders as well, and I have to give credit for the presidencies of India, but also Brazil in terms of engaging think tanks and academia and civil society in this conversation that often is very hard to take place in the UN level as well in terms of the dynamicism, right? There's much more flexibility in terms of processes that the presidency can bring, the different presidencies can bring and give their own flavor. And then my question would be to our South African colleague who's online, given that this is a panel around the G20 and data and AI, how is this being shaping in the preparation for the presidency of South Africa, and how are academia and civil society organizing themselves to include within that agenda as well a priority? And I see that this is an opportunity not only to shape a conversation globally, as we said, within the G20 and bring other countries on board in terms of the narrative. The Indians have done that very well within their DPI agenda. They've been very successful and very influential as well in the global level. But it also in terms of domestic agendas, right? How does this can also help foster and advance a conversation that often nationally becomes a bit, auxiliary or secondary in other topics. So the G20, it's that opportunity as well for countries to align their national agendas that, let's face it, within digital agendas is usually very fragmented. There's a lot of competition between different ministries and agencies that want to champion certain topics. And the G20 is that place of negotiation for national agendas as well. So it's a two-part question, but hoping that you can shed some light in terms of how you see South Africa starting to get organized to now going to that role of the presidency of the G20.
Sizwe, are you still with us?
Yes, I am. Can I answer that?
Yeah, fantastic.
Thank you. Yes, I like the question because it's a very relevant question. So with this year having been a election year, I can tell you with almost 100% certainty that our drafters of our laws have not been busy drafting laws at the moment. They've been busy with politics and trying to get voters. But I can tell you though that with any international event that happens in South Africa, be it the BRICS event last year or now the G20 event, civil society is very strong. Civil society is very strong in advising government and assisting our government in shaping policies as well as drafting legislations that are in line with international best practice. Our constitution actually requires that. So it may be quiet at the moment. I think once the parliamentarians settle in and our ministers settle into their jobs, I think in the next month or two, we will start seeing a lot of movement towards the presidency of South Africa of the G20, as well as shaping, like I said, policy towards international best practice and the discussions that are taking place around the globe. I hope that answers you.
Thank you very much, Cesar. And I think also you bring into the discussion a very important element, which is political stability. And I think that is something very evident when we analyze last year G20 declaration, where India seized the occasion to shine and to show to the world what they have been working for 10 years, basically, and then to successfully then lobby for this around the world. So this morning we were hearing from Secretary Luana Hunkarachi that in the Brazilian digital government strategy, there is mention to digital public infrastructure, which was a concept totally unheard of in Brazil until the G20 declaration of last year. So I think that none of the G20 declarations is binding, but they can be very influential. And I think that one has lowered his or her expectation with regard to what the direct impact of it can be. It is not the declaration of the G20 that will tell us which kind of risk of AI have to be regulated and how, but it can successfully introduce ideas and share ideas, and is a very good diplomatic venue to share ideas and to try to build things. And I think that has a huge values in diplomatic term, and I think that we can witness this. However, to be successful in promoting ideas, one has to have a plan, as everything in life, and consistency. And what Cesar was bringing into the discussion, the fact that South Africa just had the recent elections and the government now will change, that brings, this disrupts consistency and coherence in policies and politics. So, and that is also a reason why we see now maybe the current Brazilian presidency not a shining example of organization, not because people are not in good faith or not working like hell, because they are. Honestly, many of us know a lot of people in the Brazilian government, and they really are working extremely hard, and many of them are extremely competent, but they are a new government. I mean, in some ministries, I mean, the secretaries are still going to be, are still appointed in the past months. So it's very difficult to construct an international agenda when you don't have yet a consistent internal one, right? And that is why some countries when we analyze the BRICS countries, that's frequently an issue of discussion. I mean, India is not a mystery that India, Russia, China managed to have enormous digital transformation over the past 2 decades because the government is always the same. So it helps. Now it presents a lot of other problems, but in terms of having a vision and implementing it is much easier, right? Do we have any final remarks? Otherwise, we started with 10 minutes of delay, we are 10 minutes late. So I think we can call it a day. Do we have any final illuminating remark, question, comment? Nope. Fantastic. So let me thank very much our distinguished panelists and our online panelists and all our participants here for the excellent comments and questions. And there is still a batch of sessions after the coffee, and there is coffee now. Thank you very much.